Bring in now former federal prosecutor Shan Wu for more legal analysis now. Shan, so good to see you. I mean, prosecutors say Arbery was chased down and killed. You saw that on the videotape. The defense attorneys say it was self-defense. I mean, does the video speak louder than their words?
Absolutely, Fred. The video speaks much louder than their words. There's going to be a strategic decision about their words. They're going to have to decide if they're actually going to testify to try to explain their actions. But that evidence is very powerful evidence for the prosecution at this point, because it really raises such a specter of the terrible violent history in our country of lynchings, frankly.
And there was this citizen's arrest law in place at the time. Roddie, made reference to that. It has since been repealed, but how will the defense use that law to their advantage?
They're primarily going to try to argue, as we've seen in the opening, that these were citizens engaged in a lawful action. It was not a lynch mob. It wasn't racially motivated, that they had a right at that time, as the judge will ultimately instruct them, that they could basically act as deputized citizens. The other side of that, of course, is it's very much vigilante justice, and that's probably why that law was repealed.
And then, of course, the prosecution was successful in helping to argue the Confederate flag that is on the front of their vehicle, and the words that were also shouted out, by these, alleged, suspects, the defendants, before opening fire. How powerful are those elements going to be in how this was racially motivated?
Those are very powerful elements, and there was a fight beforehand where the defense wanted to keep that out, arguing that it was too prejudicial. But always important to remember for our viewers that the standard isn't whether it's prejudicial or not. If that was the case, nothing would get in, because it's going to help one side or the other. It has to be balanced, as the judge did in this case, as to whether it's probative. And for a murder charge here, the intent, the motivation behind it is important, and that is strong evidence that there may have been racial animus here. And of course, there's also separately a Department of Justice hate crimes prosecution going on.
This was so hard, obviously, for Arbery's mother to watch, and really for even the jurors. Some of the jurors grimacing, covering their faces. So what can be more impactful than that video?
I think that video is very much the heart of the case. I think that that's why it's such a hard decision for the defense counsel. They're going to need to try to put a face, humanize, if you will, their clients. The prosecution's job is to make it real to the jury. This was a human being, a young man who was not charged with any crime. The defense needs to try to make their people sound like they're reasonable people. And that's going to be a tough choice for them. It's hard to do without actually hearing from the defendants, but very dangerous to put on the defendant. When I was a prosecutor, I was rubbing my hands with glee if the defendant was going to testify, because you can really do a lot of damage to them on cross-examination.
So one question that's being asked over and over is why this trial was allowed to move forward despite complaints from the prosecution over discrimination in the jury selection. It's an all-white jury.
Yes, so that actually, really quite fascinating, stems from the lawyers' abilities on both sides, prosecution and defense, to use what they call peremptory challenges. And the United States Supreme Court case in Batson allows challenges which could get rid of jurors of any race as long as the lawyer can offer a race-neutral challenge. Now, ironically, Batson was meant to combat racism in juries, but as time has gone on, it's become clear that it's easy to evade that. It's very easy to present a race-neutral reason. When I was a young prosecutor in our training, one grizzled supervisor would say, it's the redheaded rule, which is, of course, you're never striking somebody for a racial reason, but if you just don't like redheads, that would be fine. That's an exaggeration, but people can always come up with a race-neutral reason. So you hear the judge here expressing some frustration that he thinks there may be some racial intentionality behind those striking. Now, I have to put that back on the judge. If that's what the judge thinks, he ought to do something about that and sustain the challenges. But so long as a lawyer can offer what appears to be race-neutral reasons for striking it, that ultimate composition doesn't matter and can be very biased, as you see here.
Yeah, and I should say a nearly all-white jury.
Right.
All right, Shan Wu, thank you so much. Good to see you.
Good to see you, Fred.